Court says something's constitutional doesn't mean it really is constitutional. And it also doesn't mean it's good policy. I'm hoping that the Supreme Court will do the right thing, but if it doesn't, you just have to attack the bill on all fronts. Certainly, in some ways I wrote this before, like a few months ago, but public, fortunately, has not lost interest in this. They've lost interest somewhat, though, I hate to say. I think they've lost some interest the last few months. But they won't lose interest because the Supreme Court is going to hear the case. And everybody's going to be paying attention. And when the Supreme Court could be, I don't know, very soon decides to hear the case, it's going to be front pages. And when the Supreme Court hears the case, oral arguments, we're going to hear about it. And people are going to be waiting anxiously. And it's going to be the big story of the next 6 or 7 months. That's it. There's my email address. There's our website. And I'll take questions and discussion.
Why would it be so late? They can put a bill and put it in. After it's in, why can't they write a bill to take it out?
They can. And I just think...
Or defund it. I know they're going to try to defund it. Yeah.
I think it's already difficult politically. Well, it's impossible politically to get rid of it now. But if there was Republican president, Republican Congress, and Senate and the House, it would be. I think it would be tougher. This is my opinion. I think it'd be tougher to make the case if the Supreme Court has ruled it constitutional. It doesn't mean that Congress wouldn't try to repeal it and the president wouldn't sign it. I think they still would. And who knows? Look at the left. The Citizens United case dealing with corporations and unions and the ability to spend money out of general treasury funds to support or oppose candidates. The Supreme Court ruled that corporations could use their own money to support or oppose candidates, right? So the left has made this out to be this horrible decision. The fact that the Supreme Court said it was constitutional doesn't mean there's probably not more desire to kind of get rid of than to try to do whatever they can to make sure that corporations can't influence elections. So who knows? Maybe I'm wrong. Maybe I do think it would be a little bit more difficult.
Maybe they can tear it apart without doing the whole thing in a little bit of time.
Could they put it on the ballot and let the people make the decision? I mean,
we don't really have that kind of process in the U.S.
We don't have that kind of process either, but it's done.
No, we don't have a ballot.
Yeah, it's by the state.
Well, I mean, if you're going to do that, then you're taking like a constitutional amendment. Then that would be far more difficult than just getting rid of it through the Congress passing a bill. I mean, because if the Republicans had control, then you wouldn't, you'd have the filibuster issue in the Senate. So that would make it more difficult. So you'd have to get 60 senators. So it would be pretty difficult. At least you wouldn't have to worry about a veto. It would be pretty difficult. Things would have to really change. But who knows what would happen in the next election. And it'd be interesting to see what's going to happen if it is found. I'll tell you what's going to happen. If it's found unconstitutional, you're going to hear the people on the left scream, oh, judicial activism, judicial activism. That'd be absurd. I don't care how you want to define judicial activism. Anytime you actually look to the meaning of the Constitution and ground a decision based on the Constitution, that's not judicial activism. That's kind of the opposite. That's doing what you're supposed to do. You're interpreting laws, interpreting the Constitution. Judicial activism is when you look at a law and you strike it down, grounded in no basis of law whatsoever. That's judicial activism. You're doing it based on your own personal preferences.
And then they go back to cases from before where if they made a mistake and then they just keep following the same mistake.
Well,
why can't they go back to the Constitution? I mean, that's their job. They're going to be there the rest of their life.
It's a great question. It's one of the questions about how much should courts follow past precedent. It's a concept called stare decisis. And see, on one hand, it is good for courts to follow past precedent because you want there to be predictability in the law, and you don't want judges to always reinvent the wheel. And on the other hand, you're right. There are going to be times when the court got so wrong in the past that why shouldn't the Supreme Court feel empowered enough to just strike down the previous case? Cuts both ways, because the other side could make the same argument and say, we're just going to ignore that case. So I agree, and we could have a whole interesting debate and discussion about to what extent courts, and when should courts ignore past precedent. But yeah, it's an important point.
Dig out the Constitution. How big is it?
Well, but sometimes, sometimes the Constitution, honestly, doesn't always give you the answer. There are times when you do have to figure out, there is some vague language, and you do have to interpret it to some extent. So, if I wish it was that easy. And a lot of times it is. But that doesn't keep the court from making stuff up. So you're right. And in those situations where they're making stuff up, that's when I think it is appropriate for the court to reverse and not worry about past precedent. Did you have a question?
Yes, sir.
Okay.
So, John Marshall, he was our second Supreme Court Chief Justice.
Mm-hmm.
John Jay was our first. They set original precedents. Why couldn't you use earlier precedents to, against more recent precedents? Has that ever happened? Because it was closer to the founding, so it was more pure. You know what I mean? It's more pure. They understood it better. They understood the founding better. As we've gotten away from that, we've become more dissolved.
I think if you had a situation where there was a case in, I don't know, I'm just making it up, 1800, and then in case 1850, and the 1850 case reversed the 1800 case, generally the newer case is treated as the good law, and that's sort of the precedent. Now, it's not a bad point. It is possible to say that the 1850 case was wrong, the 1800 case had it right, and that was actually the better precedent, and I think you could make that argument. And I think, look, there's nothing to prevent the courts from doing that.
Yeah.
They can do that, but again, it goes back to the whole respecting precedent thing. On the other hand,
suppose you put Roe in there. There's a new one right there. Right? There's something that's been going to change that law. Roe versus there's a law. One you could jump right in there. If you feel it's wrong and that sort of thing. Let me ask you something about immigration. Let's tie it in a little bit with that. As far as everybody having to have insurance, and you have to have proof of insurance. Okay. What do you think that would do as far as illegals and those people that don't have it, that haven't purchased it because they're illegals, going to the emergency room? What would you do then?
It won't matter, then.
Huh?
Why would it matter? They're not required to have health insurance.
What's that?
They're not required to have health insurance, the illegal immigrants. So it won't have any impact on them.
So, of course, you would know it, though, right? Who came in and did
In
not
fact,
have that sort of thing?
In fact, I should point out also, even if I was to go to the emergency room, the fact that I don't have proof of insurance is not going to get me in trouble. I only get in trouble when the IRS is the enforcement body here. The hospitals or whatever medical treatment facility is not going to alert somebody to it. So it wouldn't really have an impact even on even citizens. So I don't think it would have an impact.
How does the long-term disability clause that was they did away with like last week because they couldn't fund it, does that weaken the case, or is it that just one part of it that just fell apart?
Honestly, I don't know enough about what they didn't fund the provision or the program or.
They were counting on people buying private long-term disability to fund that area of it, and they found out that they were not going to be able to, since they couldn't force you to buy that, they weren't. I think they saw that they weren't going to have enough people to buy that they could implement that part of it.
5 years ahead of time.
Right,
couldn't
right,
afford it.
right. They were going to fund it way ahead. Might have even been 10 years. Yeah.
I think it just helps in the policy argument. I'm not sure how it helps in the constitutional area. There are other questions over here?
Sure.
Okay.
I don't think less than 5 people determine turn this health care plan on 300 million people out there. Especially when they appointed a liberal judge to the Supreme Court, this lady that helped pass information on his birth certificate. My statement. Rest in peace.
Well, I was at a symposium, colloquium, I don't know, with a bunch of attorneys, and it was always fun. But it was actually fun, and we were discussing, some people were pretty upset about the Supreme Court, and some people a little more radical than others, and just about how just get rid of the Supreme Court. And we don't, I don't want to go that far, but it absolutely it is a concern when 5 people, well, 9 people, but really 5 people can determine, have so much power. I mean, certainly that's an issue. And there are worthy discussions as to whether or not should individuals have, should Supreme Court justices have lifetime appointments. I mean, it's something that's being discussed. I think some political candidates might be discussing it. But I will say that you have to have an independent judiciary. And I always think, I saw something in the News Observer, and they had an interesting editorial on some of the candidates and how I think it was maybe Governor Perry that's talked about not having lifetime service on the court. I don't know if it would make a difference if let's say you made it 10 years or something, whether or not that would really ruin the ability for, I think judges would still be independent, even if it wasn't lifetime tenure. On the other hand, I'm not really sure how making it 10 years would necessarily change how judges necessarily would rule. So I don't know what the benefit is of it, to be honest. But I do see the benefit of the independent judiciary. I'm not going to sit here and say I have an absolutely brilliant answer as to how to. We were discussing this for a whole weekend. A bunch of people have thought about it a lot. It's very difficult. How do you ensure that the justices and judges really aren't activist judges, and they really do follow the Constitution? It's hard to come up with an answer. And I think it is worth discussing questions like, I think it is worth discussing whether or not it should be a lifetime appointment, whether or not how the judges are appointed. That's worth.
You can never get that through a change in the Constitution.
No, and I don't.
If so, we ought to get term limits and everything. Then we make some kind of stop.
Well,
in the legislature.
I think that the way to address something like if this was found constitutional is it probably will have to be through a constitutional amendment, or even Congress. Let's say Congress did decide to repeal Obamacare. The problem is, and this is sometimes this is something I'd argued before, is maybe you're better off not even having this case heard by the Supreme Court, because it's going to be close. So if the Supreme Court decides that it is constitutional, even if you repeal Obamacare, you've got a precedent now that says that Congress can mandate that you buy health insurance. And maybe, depending on how they write it, it could mean even broader, that Congress can mandate purchase of many things. So that's something you definitely don't want. So then, even if you repeal Obamacare, whatever Congress puts in, they can always change. They can create a new health care bill. They can do all kinds of stuff. So the only way to protect against that excessive congressional power is to have some type of constitutional amendment. People have talked about another constitutional convention, but there's a concern about that, because once you have a constitutional convention, it's probably going to be very difficult to limit constitutional convention to one specific issue, like let's just focus on the Commerce Clause or whatever it might be. The whole thing, kit and caboodle will be up for discussion, and then you might wind up getting provisions in the Constitution you definitely don't want in the Constitutional Convention. Let me go.
It's going to be November 1st, Tuesday, correct? So you're saying this is going to go to the Supreme Court within the next 12 months?
Oh, it's going to go.
June.
No,
June.
no, it's going to go to the Supreme Court in a matter of weeks. I mean, just because the term starts right away, they'll accept to hear cases over the next couple months. Maybe not a couple months, maybe a month and a half, maybe a couple months. So let's say they'll schedule oral argument for, I don't know, March or something. It'll be really quick, I think. Yeah, but they have to have the opinion. The opinion will definitely, if they hear the case this term, it has to be issued in June 2012.
They'll
That's
televise
why.
it on headline news. I mean, they televise the guy killing Michael Jackson on headline news every day. So that's something that affects everybody.
It'd be on C-SPAN.
But
I think
the case is not going to be against Obama.
No.
You keep saying it. It's against the Congress. All right? It's against the Congress because the Congress is the one that passed the law.
Well, I
Not
don't know.
Obama.
I mean,
okay?
I agree.
So if you put it in there in the Congress because then you went by the tax part of it, but you know daggone well that's exactly what it's going to be. The Congress they're going to come out and argue the point, okay, that the Congress has the right to pass laws, the spending, the tax people. They have that right. Okay, that's their job. And then they're going to come along with this thing and say, okay, by doing that, they're looking out to pass taxes and laws for the welfare of the people. And that's exactly what the Commerce Law says. And that's what it's going to be for.
All right, let me. Okay. It's not really against Obama or against Congress. It's about a law. But I'm not trying to blame. Well, if we want to figure out who was created the law or is the reason why the law exists, I would say that Obama plays a huge role in it because he's driving I don't know that it exists without Obama. So it's called Obamacare because people have associated it with him because it's his bill, even though he doesn't pass it, because he doesn't have the power to pass it. Congress does. So certainly Congress gets a lot of blame, and certainly Obama would get a lot of blame. So it's both. But, we call it Obamacare. Why? Because I don't want to call it the Patient Affordable Care Act. And then as it relates to the other issue, as I said earlier, no question, the federal government it won't be Congress who will argue this. I mean, they can argue it all they want. They're not going to be before the Supreme Court. The federal government, in other words, the Department of Justice, will certainly, absolutely make the tax argument. Not spending, because it has nothing to do with spending. This is a tax argument. This is about, does Congress have the power under the tax power of the United States, under Article 1, Section 8, to pass this, to impose this mandate? They will make that argument. I don't think that will go very far. I don't think that's the most, that is not as strong of an argument, and nor are the federal judges thought it's as strong of an argument as the Commerce Clause argument. Only one federal judge has even really bought into it, and that judge was Judge Wynn, who didn't decide the issue on the merits. He was just kind of saying in a footnote.
But that is the Commerce Clause.
No, it's not.
That is very good.
You have the tax power, and then you have the Commerce Clause.
Commerce itself.
Right. No, Commerce Clause. So you have the all right, so tax power, I think they lose on.
Based on
Commerce Clause, they, I think, will lose too, but I think this is where their best chances is under the Commerce Clause. And the Commerce Clause is Congress's power to regulate commerce between interstate commerce and whatever. This is where Congress has been given extensive amount of power, is under the Commerce Clause. So yes, I think that if the Supreme Court rules is constitutional, they're going to say that Congress has the power to impose an individual mandate because they have the power under the Commerce Clause of the United States Constitution. That'll be why. It won't be because of the tax power, which is separate. But like I said, it is possible they may with the tax power. Is there some other questions?
just wonder if Congress has the power to fund, do they have the right or the power to defund?
Absolutely.
Well, why can't they do that?
They can. You just have to get the political will to do it. So you have to get the Senate and the Democrats and the House to do it. Well, and not to mention, you still have Obama in the presidency. So even though Congress has spending power, a bill has to be signed by the president. So
Got to go through the Senate too.
and it has to go through the Senate. So if we took a snapshot today, you're not going to get anywhere politically. Let's assume June 2012, the Supreme Court declares it to be constitutional. Unless, say, Republicans do really well in the next election in November, so it's a Republican Senate, Republican House. The question is going to be, does the Republican Senate have the ability to not have to worry about filibusters? And then you have to worry about, is the president Republican? Let's say the president's Republican, Republican House, Republican Senate. The bigger challenge might be, is there enough Republicans in the Senate? If there are, you might be able to repeal the whole bill. And quite honestly, if you had that many Republicans, I don't even think you'd have to worry about defunding at that point. You'd probably just repeal it. So we'll see. I think let's hope the court gets it right, but I want to place bets.